Yeah, yeah. Yes. Actually, I don't know. The Dorsey connections are, the partners are. Yeah, yeah. Oh, yeah.
Next. See you again. I think you make it. Morning.
Well.
Sounds like those good floors for you.
Yeah. Yeah, yeah. He's a great guy. Yeah. Him and Chip.
I want to introduce you to my daughter.
Okay.
She's here for a moment. Yeah.
Just basically like yesterday, it's like in Greer's Park, and it's like a laser tag people who like go from laser tags to get coffee.
Yeah. She's been driving out getting close. He's from, I do think that
short night for us.
Oh, it's hard to leave, yeah. I thought you meant you were gonna try to leave early, but it's hard to leave. So take your day back early.
Oh, where? Over lunch, yeah. Oh, and the Skyway thing was, when I went there, there's for lunch,
Anything comes up, are you guys local to the end of the year?
So good morning, everyone. Welcome. Very glad you're here. I will say if more coffee on the way, important topic. More coffee on the way. We are going to set up one more table too in case we have a few more people pop in, but we're going to go ahead and get started. My name is Dean Eiler, and I'm a lawyer here at Great Plain Moody. And I have had the good fortune to work along with many of my colleagues on a lot of cases from the advocates. And my colleague Max Schott is on the board at Advocates and has worked with them for a long time. And many others have as well. And we really, really enjoyed the work. Really happy to be able to host the training this morning. I want us mostly to get right into the training from Sarah, but I thought I'd tell you just two things about my experience and thoughts here. The first of which is that if you're thinking about doing some work with the Advocates, you should know it's just a fabulous organization. The people are really great to work with. And we have a really good, I'll call sort of pro bono bar and set of organizations in this community in the Twin Cities that help people with legal needs in a lot of areas. And there are a lot of organizations that do really good work and that are good to work with. I think Advocates is right at the top of that set of organizations. And I say that because of the people and kind of the way that they work with private lawyers. The work is really fun and interesting as well. That doesn't hurt. But in terms of the work that they do, I've had a chance to work with Sarah many times and others of her colleagues, and they just are really very helpful and supportive in the work that you do. And so you'll hear more about the process today. But for example, the cases are screened very well. And so when you get a client, you'll know that they have met with that person. They've already got a really good set of background for you to help you understand some of the key issues. You'll have to explore more and learn more and work with the client, but you'll have a really good baseline of information. You'll have good information about deadlines and things like that to get started, which is very helpful for all of us when we have deadlines in our practices, whatever other kind of work that you do. So you'll get good information. And the other thing beyond sort of the first step that you'll get is people that are really supportive of the work that you're doing. As I said, I've worked on several of these cases. I really enjoy working on them. But I find every time I do it, there are at least a few things that I kind of have to say, I have no idea what we should do. This is a bit of a different issue, and I know I can always call or email somebody to Advocates, and it'll be really helpful. And Sarah and I were talking just this week about this training. I thought of a question for a case that we're working on, and she gave a really helpful answer right away, sent me an email with some language to use to address the particular issue that we're doing. And so if you're thinking about taking cases, this is an organization you can know that will be really helpful and be really supportive of what you're going to do. And that's makes it a lot of fun to do the cases. The second thing I tell you just a bit from my experience is the work is really interesting and really rewarding. You're helping people who are in very difficult situations, who come from all different types of persecution or things that they're trying to avoid. a team of people from this office worked with a woman in the last couple of years from the Cameroon, and she was the victim of something that's called levirate marriage, which basically means that when a dowry is paid, the family believes that she is living with the property of the family. I don't mean that generally the way we talk about things. I mean literally they believe that she is the property of the family. And when her husband passed away, she had to go through this very elaborate funeral set of sort of procedures and rituals. And at the end of that, she was informed that she'd had time to mourn, it was over, and now it was time she was required to marry one of his brothers. And because of this process, she was part of the family, she had to take one of them, and she did not want to do that. She told her husband she did not want to do that. And that was not, her choice was not in the cards for them, if you will. So she was literally attacked, she was sexually assaulted by her brothers-in-law, and told that it'd be okay, she'd get used to it, and she just had to abide by their family's wishes. She fled. They then confiscated a business that she had developed a couple hours from where the family kind of compound is. That was taken. She and her children were threatened, and ultimately she was able to flee and get to the United States. The case, again, I won't go into a lot of details. It had some real procedural challenges both before we got in and after, and so the case had really drug out. And so really all that matters is that sometimes delay can be good for folks in these situations. She didn't want delay because she'd been separated from her kids for now a few years, and she really wanted to get her matter decided. And so the process is challenging for anybody. It was particularly challenging because we had these strange procedural issues that I don't even know if I can explain well. I still don't fully understand, but they were a challenge for sure. Anyway, fast forward to the day before Thanksgiving last year, and we appeared for trial. Expected that we would have a trial all afternoon, and prepared her. She was ready to go and was going to do a great job. And to our great surprise, the court seemed to be interested in us trying to get the matter resolved, and sort of tried some things that she seemed to perhaps be suggesting. And the short of it is that basically before we even had to try the case, the court granted asylum. And so it's a great result. And what's really stands out to me is just the reaction. It's always good to win, right? I mean, in anything we do in the law, whether you're doing a deal or you're doing any kind of case, most of us have a fairly competitive nature. It's good to win. But this was a lot more than that. And I'm sitting at counsel table in the immigration court, and our client is a rather tall, large, kind of strong woman, and I feel her hand kind of on me. She's sort of, as she's figuring out what's happening, I'm squeezing my knee, and she just can't contain her excitement. And when we got done, before we even got out of the courtroom, we all got bear hugs from her, and I think she was still trying to understand even what all had happened. The point is, it was a really, really great experience. So I hope that you all will take cases as soon as you can and dig right into this really good work. It's really fun stuff to do, and you get to work with great people like Sarah. So Sarah, thanks for being here to do the training today, and I'll let you take it away.
All right, well, thanks to Dean and thanks to Great Plant Moody for hosting us this morning. Again, as Dean said, I think there's some more coffee coming, and there's some pastries and things over there. We've got a couple breaks worked into the session today, but feel free to get up whatever you need. There's lots of places to view the slides, and the first part we'll be working with the PowerPoints, and then we'll kind of dig into some of the materials that you have in front of you as well. So as Dean mentioned, my name is Sarah Brennes. I'm one of the staff attorneys with the Refugee and Immigrant Program at the Advocates for Human Rights. We've been in existence for over 30 years, and our mission is to implement international human rights standards in order to promote civil society and reinforce the rule of law. And one of the central parts of every program in our organization is to engage volunteers. And the whole idea is that if we're able to engage volunteers in the movement, we'll have a greater impact in advancing the causes for human rights in the areas where we work. The Refugee and Immigrant Program is the one program of our organization that does direct legal services. So we work our volunteer attorneys, and we also have volunteer interpreters, and then other volunteers may come in on different cases, but we are able to leverage the work by engaging volunteers in this work. There's no way, with our very small staff, we'd ever be able to represent as many people as we do. You know, we have about, I'd say about 200 open cases at any time. We take about 100 cases a year, and there's no way we could help as many people as we do without the dedicated volunteers. Dean said it is very rewarding. I won't be shy to say that often these cases are a lot of work, and they can be a lot of time to put in, but the clients are extremely grateful, and I think for most people it is really rewarding work. I know that there's some people that signed up as a refresher, so maybe a show of hands of how many of you have handled an asylum case before. Okay, so quite a few. So maybe, so some of you are new to this, and others hopefully things will be very familiar. So what we're going to do for this first section is I'm going to give you an overview of asylum law, and walk through the different key parts of the of what you need to prove in any particular asylum case. So basically, asylum. I think one of the big questions we get from people is, well, what's the difference between an asylee and a refugee? And essentially, an asylee is someone who has come into the United States either as a student or as a visitor or without any documentation. And then once they're already in the US, they're seeking to be recognized as a refugee. The refugees that we have in our community are recognized as refugees outside of the United States, and then enter already recognized as refugee. They have access to the benefits that go along with it. There's, you know, they're authorized to work. They have access to certain social services. Asylees are not always in that situation. We do have some clients that are either in school or they might be working, but all of the clients that we're working with are low income, and many have come with the luggage they came with, and they're doing couch hopping, and they're not allowed to work until their application's been pending for 6 months. So on top of the legal work, there are other challenges that many of our clients are facing. And one of the things that we do as an organization, in addition to connecting clients with volunteer attorneys, is to also provide referrals for some of the social services and get them connected with places where they are able to get help, regardless of their immigration status. So the sources of immigration or asylum law are varied. Essentially, it's from the 1951 Convention relating to the status of refugees and the 1967 Protocol. The US passed the Refugee Act in 1980, and then primarily the focus of the legal research will be in Section 208 of the Immigration and Nationality Act and the corresponding regulations, and then a very deep pool of case law. And our case law comes from, here in our jurisdiction, the 8th Circuit. There's also Board of Immigration Appeals, and then to a much lesser extent, and not precedential by any means, the immigration judges issue decisions in their cases, and then at the asylum office level, they usually don't give you much to work with, but you might see trends there. But in comparison to other areas of immigration law, it certainly reaches a broader international context than some of the other areas. So the crux, the definition of asylum, we're going to give you different types of learners. This is going to be our text version of the definition, is any person who's outside any country of such person's nationality, or in the case of a person having no nationalities, outside any country in which such person last habitually resided, and who's unable or unwilling to return to, and unable or unwilling to avail himself or herself of the protection of that country because of persecution or a well-founded fear of persecution on account of race, religion, nationality, membership in a particular social group, or political opinion. And I would say most of the cases from the focus on the area of because of persecution. Each part of the definition has a a long history of case law. But the crux of the work is there. The one piece I think it gets a little confusing is, you know, in most cases our clients are from one particular country, they're a citizen of one country, but in some instances we'll have someone who's considered stateless. We have some of those clients that add that extra layer, but for the most part, people are citizens of one country. So our more visual definition breaks it down. So first of all, you have to be outside of your country nationality, which is fairly easy to prove if they're already here in the United States, and then have to have a well-founded fear. And that's gonna, we'll talk about in a moment here, but there are two components. There's both the subjective component, which isn't too difficult to establish, and then an objective component. Is it reasonable for that person to have that fear? And then a fear of persecution. So either there's a history of persecution in the past, or for some specific reasons they fear that they'll be persecuted in the future. And we'll talk about the definition of persecution in just a moment as well. And then it has to be on account of, there needs to be a nexus to one of what are called the protected groups. So it has to be on account of someone's race, on account of their religion, their nationality, their membership in some particular social group, or the political opinion. The most common cases we see are political opinion cases and religion-based cases. And then the particular social group cases have their own sea of case law by themselves. They tend to be sometimes some of the more challenging cases, though there are certain particular social groups where the law is a little more settled and can be straightforward. And then finally, the applicant needs to establish that the government won't protect them, either because the government is the one who's inflicting the harm, or the government cannot or will not protect them for some reason. And this is just another textual version. And then they can't be barred. There's certain bars to asylum. One of the ones that we screen for right away is there's a 1-year filing deadline. You have to file asylum within 1 year of your last entry to the United States. So that's usually, we're flagging that for the volunteers, because you need to get that application filed by that deadline. And we'll talk about at the end of the PowerPoint some of the other alternative forms of relief that might be available if folks don't meet that deadline. And sometimes there are exceptions that apply, but for the most part, people find us shortly after they enter, before the deadline happens, and it's a priority to get it filed for them. Okay, so persecution. We're going to break down each of the elements and go in a little more depth. There's actually no statutory definition of persecution that's come out of case law. And essentially in our circuit, they've defined it as the infliction of death, torture, or injury to one's person or freedom. So depending on the case, what is important to show is that it's more than harassment or discrimination. There has to be some infliction of harm. And in some cases, even if there is harm, they found that, you know, if someone is detained for 3 days, sometimes that might not be enough for persecution. So really finding out what are the details of the harm that someone suffered, and how many incidents happened, it can be really, really important to draw out in the application. So even though harassment and discrimination by itself won't be sufficient, cumulative harm does count. And this often comes up in cases such as domestic violence, or some cases based on sexual orientation, where there may not be one incident that the harm rose to the level of persecution, but because it happened repeatedly over a long period of time, that may constitute persecution. The other factor that is coming up a lot now, you may have heard in the news last summer that there's been an increase in the number of children fleeing Central America, and so we're taking some of those cases. And what's important in those is the Eighth Circuit actually hasn't spoken to the issue directly, but at least the asylum office is recognizing that the age that someone was when the harm occurred is relevant. So if some form of harm to a 30-year-old may not constitute persecution, but that same harm done to a 3-year-old would constitute persecution. So keeping in mind how old was your client when the incidents happened can be very important to establish that part of the definition. And then finally, punitive or malignant intent is not required. So this comes up often in cases of female genital mutilation, where the community or the family inflicts this harm on the person because of a cultural practice. The intent isn't to harm them, it's to initiate them into the culture, and that doesn't matter. If it was harm to the person and the person's viewing it as harm, then it can constitute persecution. The next thing to establish is you need to have a well-founded fear. And part of that is subjective, and again, this is the individual state of mind. Are you afraid to go back? We do would rarely take a case if someone said, I'm not afraid to go back, because that's usually the reason that they're coming to us, because they have a fear and a genuine fear of being persecuted. The issue where you'll spend a lot more time is establishing whether or not that fear is objective. And that's going to be based on the facts in the individual case, the contact the person had with the persecutor, or any ongoing threats that are happening. And then also other objective evidence or testimony, maybe other witnesses that know that this fear is substantiated by the applicant, and then whether a reasonable person in the applicant's circumstance would fear persecution. And a lot of the objective fear component comes from country condition evidence. We'll talk about this a bit later as well, but establishing that whatever the grounds are, for example, if the person is a member of a political opposition group, one of the first places we look for evidence is the Department of State issues human rights reports on countries in the world, and that'll have a narrative, and there might be a section in there that's talking about this particular political party has been targeted, there have been people that have been jailed, or protests have been broken up. But a lot of the different asylum claims that we see, there's some section that's covered in those State Department reports. We'll talk about some other types of evidence. It's pretty broad in terms of what would be acceptable in order to establish that it would be reasonable for that person to fear harm, because that type of harm is going on in the country where they're from. And then again, government protection. So there's two types of cases. One where the government is the actual persecutor, and that's usually fairly easy to establish that the government won't protect you if they're the ones that are harming you. And it can be because there was specific past harm to the applicant, or there's some pattern or practice of persecution of the protected group that they're from. So, perhaps they are a member of a certain religious group, and they may not have been harmed in the past, but there's country condition information that's saying that these members of this religious group are being targeted by the government. And if that evidence is there and is substantial, then you may have a claim. The other cases are where there's a non-government actor who's persecuting your client. And there's a couple ways to go about establishing that the government cannot protect them or will not protect them. Either they've asked the government for help and they've either refused to help, or whatever help they offered was inadequate. They answered a police call, but then the person was never arrested, there were never any charges filed, etc. Or there may be cases where the client didn't even contact the government because they knew they wouldn't do anything about it. And this comes up in a lot of the domestic violence cases, where it's well established that the government sees domestic violence as a family issue and they're not getting involved. And if you can establish that that's how your client saw it and that's why they didn't seek protection, and there is evidence showing that the government would not have protected your client, then that prong may be met as well. There's another component. It's always sort of chicken or the egg with a lot of these elements, but I want to talk about the burden shift that happens, and both of these last few components factor into it. So there's a different burden shift that happens if your client actually was subjected to past persecution. And I would say most of our cases, there is at least an argument that the client suffered past persecution. If that's established, if it is true that they were persecuted in the past, then essentially the burden is shifting back to the government. And the government can rebut the argument, saying either there's some changed circumstance that well-founded fear no longer exists, or that the person could reasonably relocate to another part of the country. And again, the who is the persecutor comes into play here, because if the government is persecuting you, then it's, the government is everywhere, and it wouldn't be reasonable for you to relocate everywhere. The law is fairly settled on that. If it's a non-government actor, then there are more factors to get involved, but it's more than just the persecutor being able to find your client. There's a specific section of the regulations that describe these other factors. It can be, you take into fact civil strife, societal norms, do they have family connections somewhere else, are there barriers for them actually living safely in another part of the country and, finding work, etc. That goes into establishing whether or not the government has rebutted. And in the cases of past persecution, even if the government established circumstances have changed, the person can relocate somewhere else, the burden shifts back to the applicant to show that, and they can show either that the past persecution was so severe that they shouldn't be subjected to going back to the country, or they'd suffer some other serious harm. And there's two interesting cases, and these can sometimes be the most interesting ones we see, but oftentimes require the most advocacy because they aren't quite as common. There was a case that we had several years ago that involved a young man who was a child during the Liberian Civil War, and he was locked in a closet while his family was killed. And the judge said that, and so part of the argument was, well, the circumstances had changed. He's much older now. The country is in a different place, and so he could return. And the judge initially didn't grant his case, but the board came back and said that that because he was so young and because he heard the events that happened, that it was severe enough persecution that he shouldn't be required to go back. There's another case that some volunteers recently won that involved a young woman who was an infant during the Guatemalan Civil War, and she was indigenous, and her family had been targeted, and some of her family members had been killed and had to relocate, and were impacted by the events of the Civil War. And the judge actually found her more recent flight to the United States was related to the gang violence, and her family was being extorted, which in and of itself has been a really challenging claim to bring. But the judge found that because she was an infant and the severity of the events that happened, that was past persecution. And even though the country has changed, she would face some other serious harm in these other events that had happened more recently with the gangs, and she was ultimately granted asylum. So these cases do come up, but it's important to keep in mind in some of the things while you're laying out the case to factor these in. And even though you sort of make the argument for everything, assume that the government is going to try to make an argument that circumstances have changed or they can relocate, and preempting that by establishing why it wouldn't be reasonable and why the situation is still dangerous if there is a claim of past persecution. On the other hand, if there's future persecution, the applicant keeps the entire burden and has to establish that they have a fear of persecution, and there's a reasonable possibility that they would be persecuted, either because they've been singled out, they've received repeated threats, someone's looking for them back in the home country, or that there's a pattern or practice of persecution of the protected group that the applicant belongs to. And then they have to establish that they're unable and unwilling to return due to the fear, and that it would be unreasonable, so, to relocate to another part of the country. So all of those elements are left with the applicant to establish. So as I mentioned in the definition, the protected grounds include race, religion, nationality, political opinion, and particular social group. The law says that the protected grounds, so one of these protected grounds has to be one central reason that the person is being targeted by the persecutors. It does not need to be the central reason. So that's important to keep in mind. If it seems like there's multiple reasons the persecutor is targeting your client, it's important to sort of tease out, well, what are the direct or circumstantial factors that would show that one of the central reasons they're targeting them is based on one of these protected grounds. There can be multiple grounds. They could be targeted, sometimes some political groups, they tend to be from the same religion perhaps, so there might be some multiple grounds or overlapping grounds there. Sometimes with the domestic violence cases, there's the argument that they're a member of a particular social group, but also facts in the case may show that they're exercising a political opinion, or there's some imputed opinion that's being implied by the persecutor upon the applicant. And then the persecutor can have mixed motives. They can have a reason that's related to one of the protected grounds, as well as other reasons, as I stated, but again, just going back to really sort of recognizing what those other reasons might be, but showing how the facts and evidence establish that one of the central reasons is for one of these protected grounds. We're gonna go in a little more depth because it is, yeah.
So, would you recommend that you pick one instead of going with three, because then you have to establish the fact that why these other two reasons are also the big reasons of the file all facts.
You mean if there's like,
Like, there's the race, religion, and political opinion.
Sure.
If the applicant says, because of those three things, you're not persecuted, so you as the filer pick all these three, and then you have to support why race, why religion, why political. Do you have to do that, or?
Yeah, so the question was whether you should, if there are multiple reasons, if you should just go with one, or lay out the argument for each one. And I would say lay out the argument for each one, because particularly if you're very early in the game, trying to preserve that. And I mean, sometimes you're making the argument for the three, and then if you're before the judge, for example, the judge comes in with, well, this is my thought, whichever one she wants to grant on, we'll take. But in order to really preserve that opportunity to appeal it. But I mean, I can see the issue in terms of, well, will it weaken the other ones if you're making the argument? But again, I mean, really trying to focus on the fact that it's, one central reason, not the central reason, and there can be multiple central reasons for the targeting. And I think sometimes what happens is there might be different incidents or even different persecutors that are targeting people for different reasons. So it may turn out that you're sort of making different mini claims for asylum because there might be family members that are going after someone for one of the reasons, and then there might be a government persecutor for another reason. And trying to put everything out there as strong as the facts will establish it, and you don't only need one of them to prevail. So. But good question. So we're going to talk a little bit more about particular social group, because if you do have a claim that involves a particular social group, there's a bit more that you need to do to establish that the group actually meets the criteria under the law. In the first, the most long-standing case, the seminal case on particular social group is Matter of Acosta. It's a 1985 Board of Immigration Appeals case that basically states that in order to be a particular social group, the members of the group have to have a common immutable characteristic. and one that they either cannot or should not be required to change because it's fundamental to their identity. And that's been a longstanding law. Some of the examples given in Matter of Acosta were sex, color, kinship ties, and certain past experiences. What has happened over time and more recently is the board has added on a few other layers to this. And now the current law, though I would say it's debated still among the different circuits, is requiring that in addition to be an immutable characteristic, it also needs to be socially distinct and particular. Both of these factors, if you read some of the case law, it is confusing and they sort of weave each other, and I think it's the board's attempt to try to prevent certain types of claims, but I think it's caused more confusion. In most of the cases, they're adding to the case law in instances where they're denying a claim, but rarely have they really given us some good guidance of, okay, well, here's one that clearly fits into the group. The one exception is there was a good domestic violence-based claim that came out recently that did meet their standards. So, but first, the social distinction piece is essentially the society sees this group as distinct within the society, so within the country in question, and it's specific to the broader society. So it's not just that the persecutor sees them as a group, but society at large does. The other piece is that it has to be particular, so there needs to be some sort of outer limits to the group. So a couple examples might be landowners in one country may be particular but may not be in another country. Case laws establish that some terms may be too vague, such as wealth, poverty, homelessness, youth, but there's been a lot of experimentation to try to figure out, well, is there, some subpopulation of youth that are viewed in society in some particular way that I mean, you don't have to list statistics or numbers, but it does need to, you need to be able to say there are certain people that are in this group and there are certain people that are not. And I think this has been one of the challenge with the gang-based violence in Central America, because the government usually says, well, they're just going after everyone. They don't care who you are, where you're from, they just want to go after everyone in society. So that's been one of the challenges there. A couple other things on particular social group is that it can't be defined by the harm itself. Victims of domestic violence isn't a social group. I would say it can be a common group if they're being harmed because they're victims of domestic violence. But if the actual persecution is the domestic violence itself, then the group can't be defined by the harm. It's important to keep in mind what are the controlling circuit law and BIA decisions on any particular social groups. Multiple particular social groups are okay. So again, we've seen this before. The board really came up with a strong domestic violence case. A lot of the claims were saying, well, the client is a Guatemalan woman. The client is a married Guatemalan woman. The client's a married Guatemalan woman who's unable to leave the relationship, and sort of making the argument for each of these different groups that she could fit into all of them. Which one meets the standard of the law is the point at issue. And then it's one of the other important things is to distinguish the particular social group from the nexus. So, again, this is talking about the particular social group has to exist separate and apart from the harm from the persecutor. And that society has to see the group in existence, and then because they were part of that group, the persecutor targeted them. So first addressing the particular social group exists, and then addressing the issue of nexus, that because they were a member of that group, that is why they were targeted by the persecutor. This is just an example of the board case of domestic violence, and the particular social group that was upheld, married women in Guatemala who are unable to leave the relationship. And you'll see that how the different elements are sort of overlapping. Is, you know, you have women, all right, that's about 50% of the population, and then you have women that are, well, first of all, establishing, well, what's the country? Because usually, I mean, that's going to be fairly straightforward and important in sort of setting your context for the particular client. Their gender, and then they're married and they're unable to leave the relationship. We have seen, I mean, it's fairly well established that the actual legal marriage isn't as essential if you can establish they're, you know, in a relationship that they're unable to leave. And this has overlapped as well into some of the other domestic violence cases, that it might be parental or some other family member who's being abusive, but, you know, they're in some sort of family relationship that they're unable to leave. So breaking this down a little bit and establishing how is this immutable, it may be related to religious beliefs or cultural norms, legal restraints that makes it such that they're not able to leave that relationship, or unable to change their status as a Guatemalan married woman. And then also looking at the factors that what's making it impossible for them to leave. Is it, you know, economic limitations? If they try to leave on their own, they wouldn't be able to support themselves. Are there societal norms that would make it taboo for them to leave the relationship? And probably the biggest one that the adjudicators look at is, you know, are there some physical constraints? Is the persecutor not allowing them to leave the relationship? They're repeatedly going after them and finding them despite efforts to try to escape. And then that broader societal view, where country conditions and perhaps an expert statement are very important to sort of explain the context of the society that would make this group recognizable as a particular group. The social distinction element, you can look at their relationship status, the prevalence of domestic violence in the country may show that this group is socially distinct within the society, societal attitudes, the historical context. You know, in Latin American countries, the concept of machismo factors into a lot of these types of claims. And even, you know, the availability of state protection may also contribute to establishing that this group is distinct within society, because either there are or they're not specific ways that they're protected, and even looking at some of the laws themselves that may or may not protect women in marriages or in relationships. And then some of the other things in terms of looking at is there are there boundaries to the group? You might look at some of the domestic laws and marriage laws, common law marriage to, you know, establish some distinction from folks that are just living together but are not necessarily married. Is there some law that talks about when is someone considered to be in a common law marriage, and the basic definition of family in the country. Sometimes folks have also used the actual immigration definition of a crime of domestic violence that has some good language that sort of talks about when that definition wouldn't apply, and sort of transport into the context of the particular country. And then sometimes looking at subgroups. And this we've seen in some of the cases where there's gang violence for young women, and looking at the start of the relationship, the length of time someone's been in the relationship, or how recently they fled, and whether or not that creates some boundaries to the the case that came out from the board, I think is, usually when we have a domestic violence case, we really encourage folks to kind of read through it and see how your particular case compares to it. And this piece of establishing the particular social group for domestic violence-based cases is not quite as challenged as it was before that board decision came out. Where we're seeing a lot of experimentation and attempts to try to frame this is in some of the cases for the kids that are being targeted by gangs for recruitment particularly, and again, the government's argument is they're going after anyone, but we think there is an argument. Some kids, we asked them, well, why do you think that the gangs were targeting you? And they said, well, they know that kids under 16 can get away with a lot more crimes than kids that are over 16, and so looking at those laws of how does that make that subgroup exist within society, and then that next step establishing, and that's the reason that the gang was targeting them in particular. The other thing to keep in mind always, the particular social groups, particularly if it's not one that's with very settled law, it's always good to see if there's another alternative argument. So looking at, is there some imputed political opinion? This is an example in some domestic violence cases. Is there some other reason that's one of the other 5 protected groups that might be a little more straightforward to make the argument for? And then after that, looking to the nexus and looking to, is that the reason, is the membership in that group, or is that protected group the reason that they were being targeted by the persecutor? And there are multiple things you can look at. The applicant's affidavit, we'll talk about in a little bit, is critical to the application and their testimony about what was said to them and in their particular situation. So there may be a statement to the victim that was made, for example, you're my woman and I can do whatever I want to you. This is a common language that the persecutors have used in some of these domestic violence cases. There also may be establishing that there's a pattern of violence that reflects the society's view, and this is, again, in some country condition reports that may talk about how society views domestic violence, or whatever the group is that you're making the argument for. And then societal norms in the legal system and how they treat the type of harm that the applicant fears, and how they treat those relationships within society. And I think one of the big things and one of the big criticisms of these added components for particular social groups by the board is that it's very difficult for an applicant to represent themselves and try to make a particular social group claim. I mean, it's very difficult for the attorneys to really articulate it and keep it all straight. But it's really created a barrier for a lot of people to establish that they meet it, and really, in most cases, it's requiring expert testimony to sort of explain the intricacies of the society and how they might view a group. We found some really phenomenal experts to assist in some of the cases with these types of claims, and they really are critical to making the argument. And then again, just sort of following this example and looking at examples of the government protection piece. Again, these are cases where there's a non-government actor, so there may be records of individuals calling the police and how do the police respond. We've seen a lot of cases where folks live in more rural areas and they tried to call the police, but they're 3 hours away, and so there's really no reasonable belief that they would be able to protect them at any particular incident. But there might be other records that they're able to obtain. And then in terms of an argument that they didn't call police because it would have been futile, there's you can look at some of the different information available. So for example, are there laws that carve out particular standards for domestic violence versus simple assault? Is there some sort of enhanced punishment for domestic violence cases? Is there mandatory reporting? Is there legislation on divorce that would factor into how the government would or would not protect someone? And then, so let's say there are laws in the book that, on the one hand, well, the government would say, well, look, they've got these laws that are protecting victims. So then the next step would say, well, are they actually being enforced? Are there reports about of the numbers of reports that are made, how many people are actually arrested, of the arrests, is there persecution? And I would say the Department of State has gotten better in being pretty specific and does even have some statistics on this. Our women's program also has a website where they have a lot of information on different countries that talks about these very things. These are some of the factors that the women's program looks at when they do evaluation of domestic violence laws in different countries, and these are a lot of the pieces that they look at. And then in addition, is there training that's going on? And even if all of these things exist, well, you know, what's the long-term protection that exists for someone? So sure, they can report the crime and, you know, their abuser will be sent to jail for a week, but odds are things would get worse once the person's released. So, you know, what types of shelters are available, or hotlines, and are they able to access medical attention? And really critical, what are the resources after they leave the abuser? Because if it's gonna actually put them in more harm, and there's nowhere that they could go to get protection, then they would have a good argument to say it would be futile to try to seek that protection. And then another example of some of the reasonable relocation, looking at attempts to relocate, that's usually a big question. Did they try to move around somewhere else, and how did that happen? And if they did, you know, what were the circumstances when they were living somewhere else? Did they essentially have to live in hiding to make it not reasonable for them to relocate somewhere else? So, you know, even though it's not limited to the persecutor's ability to find the person, that certainly is a very relevant factor. And then looking at some of the government bribes often comes up if the persecutor has some connection with the government, might be able to use the government to try to locate the individual. So hopefully that gives you some examples of some of these cases. It's sort of hard to choose one, and every case is very different, and all the facts are very different in all of these, but it gives you a little flavor of at least one type of case. So again, a couple of the other things just to keep in mind, again, when you're stepping back, and you know, a lot of times there's movement between being, you know, looking at the forest of the application, and then, you know, in the trees, and digging in deep to the facts. But stepping back and, you know, looking at, you know, if there's a one-year filing deadline issue, are there certain factors that can be considered to meet an exception? Sometimes if there's a mental disability, essentially for the exceptions, it's either there was some exceptional circumstance that happened during that first year. We've had clients that were in car accidents and had injuries that prevented them from making it a priority to file this paperwork with government. And then also if there's changed circumstances, you know, there may be someone who is here, and then some events happened in the home country that changed, so that they didn't have fear when they first came, but they do now outside the 1 year. Yeah. It is, yeah. If you maintain continuous valid status, yeah. Yes, yeah. So long as a person stayed, you know, they didn't have a lapse in their status, that would be an exception. It's sort of the idea that the government doesn't want to force people to have to file prematurely, and that, you know, situations change. If they have some other status, then enjoy that and do that. And so we talk to a lot of our students about that, particularly if ones, you know, they may have some employment-based immigration benefit that they could access that would allow them to stay here without having to go through the asylum process. Certainly pursuing that, and it's generally seen as you know, one of the last resorts for folks if there aren't other immigration benefits that they can take advantage of. And then again, looking at what's called humanitarian asylum, are there factors that would warrant a grant of asylum even if circumstances had changed, or they could relocate. And then we screen for other forms of relief that might be available, but it's important, you know, we tell clients that, you know, if they're a victim of a crime, and we have clients that, because the process takes long, they end up meeting a US citizen and get married, and that opens up some doors. So there might be other relief that's either available at the time we accept the case, and, you know, we encourage them to pursue those other forms of relief, or that come up during the representation. So it's important to keep those in mind. And then other prosecutorial discretion might come up if someone's in removal proceedings, and, you know, figuring out, is it worth pursuing the case? Will the government perhaps just decide to administratively close the case for factors that wouldn't warrant a grant in their opinion, but they also don't feel like really pursuing it. There's sympathetic factors. And then the other one we've added here, the special immigrant juvenile status. We've seen this a lot with some of the children from Central America, and that's for children who've been abused, neglected, or abandoned by one or both parents, and usually that's going to be in the home. In the home country, there's special provisions for them to receive status here as well in certain circumstances. So, in some of the cases, that might be a factor, and we work with the volunteers to figure out if it's something they're able to train up on and help with, or could potentially provide a referral for. In terms of benefits, an asylee is able to apply for family members, which under the law is your spouse and any children under 21 at the time the application was filed. So they can file a petition for them to receive dependent asylee status, either coming from abroad or if they're already in the United States. They can travel outside the US with a refugee travel document, though we discourage folks from going back to the home country for obvious reasons. And then after they've been an asylee for a year, they're able to become a permanent resident. They qualify for certain public benefits. Some of those start in there for a limited amount of time from the grant. And then they're eligible to work without special authorization, so they don't need to renew a work permit every year, as they have to while the application is pending. A couple of the bars that come up are if they actually have persecuted others, if they've firmly resettled, and that's basically if there's been an offer of permanent residence from another country, that would potentially be a bar. If they were previously denied asylum by an immigration judge or the Board of Immigration Appeals, not filing within 1 year, convictions of an aggravated felony or particularly serious crime, danger to national security, serious non-political crime, and terroristic activities or material support of terrorism. Some that we generally don't take cases where there's where there are multiple bars that would make it too complicated. I mean, one of our goals is that it's a strong claim, and one that we think would that our volunteers can handle. So generally, the ones with complicated criminal histories aren't ones that we take. I would say one of the things that does come up is the material support bar, and this is a very complicated and contentious provision of the law that basically says, you know, if you gave food or shelter to some group that could be considered a terrorist group, then you are barred from receiving asylum. And what we've seen a lot of these is that, you know, the law, of course, was passed after as a follow-up of 9/11, but has impacted people that are really shouldn't be considered, or, you know, never consider themselves supporting a terrorist group. But sometimes there might be like political organizations that have some violent branch to them, and, you know, they had some connections, sometimes even unknown to the applicant. And then what happens in a lot of these cases, they don't grant them, they don't deny them, but they just sort of linger in this black box for forever, it seems. But there's a lot of advocacy going on currently on these, and there've been some blanket exemptions and some other types of exemptions that have been put in place to try to get some of these folks the protection that they need and sought when they came to the U.S. For some of these bars, individuals might be eligible for withholding of removal or protection in the Convention Against Torture. Asylum can be granted both by the asylum office, and we'll talk about sort of the procedural differences in a moment here, or the immigration judge. Withholding of removal and convention against torture it can only be granted by the immigration judge or the board. So it's only if you have a case that's in removal proceedings in court. Most of our newer volunteers are handling affirmative cases before the asylum office. So there's fewer bars, there's a higher standard. For asylum, well-founded fear under case laws that there's a 1 in 10 chance that you would be persecuted. For withholding, it has to be more likely than not, so more than a 50% chance that you would be persecuted. And for withholding, you also have to meet, it needs to be on one of the protected grounds. With the Convention of Torture, it's more than 50% chance that you would be tortured by the government, or the government would allow you to be tortured for any reason whatsoever. And there are fewer benefits. These are generally, you may get a work permit, but there's no family reunification, no path to residence or citizenship or any of those things. But in some cases, it might be the only one. One of the things that, if we have someone come to us after a year and they don't seem to meet any exception, we talk with them and say, well, if you file this affirmative application, the odds are you're going to be referred to the judge, but we think you have a strong claim for withholding. So if you're happy living in the United States for the rest of your life and having to renew a work permit every year, then it may be something worth pursuing. So, but that's a discussion that we talk with folks before we hand them over to a volunteer. Okay, so I think at this point, I think we're a little over, but we'll take a short break, and then we'll kind of hit on some of these other slides and look at some of the materials in the handout. But if you want to take maybe 5 minutes, and you can stretch and grab some water.
Yeah, that's why I actually, did you as well? No, I never have, but I was a political asylum officer. Oh, good. Justice Department. It was in the very first class. Oh, wow. Because it was created in 1990, this by an act of Congress. I was working in refugees, and the asylum officer, and the only reason I was because I almost died of cancer in the United States. So I did it for just under 2 years. And so I mean, there's fascinating and so this shows how old I am. I actually went to Guantanamo Bay when the Haitians were fleeing and landed in Gitmo. So, yeah, just really interesting work. I really do listen because you can be an advocate on the inside. Sure. And so in the 2 years I was there in the Chicago zone, I brought to their attention as a kid who the Minnesota Advocates for Human Rights were. Yeah, they're like, who are they? You know, 10 years ago. So there was and Center for Victims of Torture. So there was a CVT right in the director of the office of this yeah. So you can do work inside as well as
It's good to hear. The cases I had were fairly absurd. And I didn't feel like I was getting academic inside. No.
yeah.
Well, the training. Yeah, that they showed us, so into and you're trained along with the border people. So that's something. Oh, sure. So the yeah. The deep of America.
Yeah, we did. Yeah, it was nice. That's a little rough. Terrible place to be. Yeah, yeah. We do.
Yeah, you go over Europe, it would be really interesting. Yeah. I'm gonna have everyone take out the little packet that you had. Our intern Juan did a wonderful job getting these all together, ready for us. And I just want to point out the way that it was packaged. So there's currently a little rift between the asylum office and the immigration courts on filing sort of this procedural issue. The immigration courts, they, it was about 6, 7 years ago now, created a uniform procedural manual on how you file documents and how they should be paginated and a whole bunch of all these fun things. And the asylum offices always sort of have the opinion, you know, we'll take what you give us, knowing that they're working with a lot more, I'd say, pro se applicants that are just sending in what they have, and so they don't require a formal way that things should be filed. One of the issues that we've had is that when cases are sometimes referred from the asylum office to the immigration court will sort of huff and puff because it's not, the filing doesn't meet their criteria. So we encourage people, even if they're doing an affirmative application, to lessen the burden. It's sort of a debate on whose responsibility is it to get it up according to the immigration court standards. Usually the applicants are the ones saying, okay, we'll resubmit everything since we did it before, even though it's really the government's duty to do it. So the point being, we encourage people to just follow the immigration practice manual. It's more straightforward. You know, you as the attorneys will be easier to kind of organize everything. I mean, this is sort of kind of an example of how you might include your supplement documentation, because basically your application is going to have this form, and then there's the affidavit, and then you have supporting documentation. And really looking at it as an advocacy tool. You know, the court sort of wants tabs and things broken down, but a lot of times we'll sort of, you know, lay out the claim and say, you know, here's identity documents, here's documentation showing that this particular group is being targeted in this country. This is these documents show that the government is not protecting people that are in this group. And so this is just kind of a sample of that long answer for why that is the way that it's formatted. But I'm going to have you turn to this second page. Some will have colored pages, some I think might be black and white. But this walks us through the different procedural paths for an asylum application. So most folks, when they take their first case, they're taking an affirmative case. And so this is for someone who's, you know, they entered as a visitor, a student, or they enter without inspection but haven't been identified by the Immigration Service. They're not in removal proceedings. They're able to file their application with the asylum office that's part of U.S. Citizenship and Immigration Service. And what I've got up on the screen here is sort of how the department breaks down. So the asylum office is, and that circle didn't work. It's actually part of the U.S. Citizenship and Immigration Service. And it's treated sort of as a separate branch in some regards. You can't really track the cases like you do in some of the other cases before USCIS, mostly for protection and confidentiality reasons. But that's the office that you'll mostly be working with. And this sort of lays out what you can expect in the process. You file the application, the applicant gets a notice to have their fingerprints taken, and then there's maybe a short wait, maybe a long wait. There's a significant backlog right now, but eventually they'll be called for an interview with an asylum officer. There's multiple asylum offices throughout the country. The one that has jurisdiction over cases filed in Minnesota is in Chicago, and so they make circuit rides up here to Minnesota to do interviews. They'll often come up for a week, they'll send a couple officers, and they'll do 30 interviews in a week. Applicants know about 2 to 3 weeks ahead of time, so it's not a whole lot of time, particularly if there's been a gap, if they've been waiting a while for the interview. In some circumstances you can ask to be rescheduled, but it may be a long wait before they get around to scheduling them again. But then essentially, the interview happens, it takes about an hour, hour and a half, 2 hours. And the attorney actually plays a fairly passive role. Usually you're taking notes and you have an opportunity to make a closing statement, but it's meant to be a non-adversarial interview with the applicant, and it's the officer and the applicant they're doing most of the talking. So really the attorney's role is to make the materials that are presented as clear as possible to the officer, and to prepare the client for the interview, and sort of asking them questions. And it really varies. Some officers just kind of get to the questions that they need answered to add some more information. Others will go paragraph by paragraph with the affidavit. It sort of varies. So preparing your client for all the different possibilities. There was a documentary made several years ago now called Well-Founded Fear. And it actually, despite it being a bit dated, it's a pretty good rendition of what happens during asylum interviews. I think it's available on PBS. We also have some copies in our office, but it really gives you insight to what happens during the interview and how officers handle interviewing asylum applicants. And then you don't walk out of the office with a decision. In our jurisdiction, we're most often getting notices mailed, and they'll either be a grant of asylum, or if the person's out of status when they make the decision, they will refer to them to the immigration judge. If they are in status, which I would say is a small percentage of our clients, they'd be issued a notice of intent to deny, and you can respond to that, and then they issue a final decision. And the reason being, if they deny the application, they just go back to being in whatever status they were in previously. And when we assign cases to volunteers, we tell clients, if it's an affirmative case, your attorney's helping you up until you get a decision from the office. You are not committing yourself to go represent them in court if you don't want to. Certainly, if you're up to the challenge, we will support you in that. But we'll reevaluate the case, see do they still meet our guidelines in terms of service area and income level. And then, if it's a good fit and the volunteer wants to go forward, great. If it's still a good fit but the volunteer isn't interested in doing a removal case, then we'd find another volunteer for them. Yeah.
What kind of support system do clients have as they're going through this process?
It varies. We try to work with clients and see what kind of support they need. Some of our clients, I'd say about half of our clients, are victims of torture. The Center for Victims of Torture is in the Twin Cities here, and really is a great support to clients for mental health services, and they have case managers there as well that can connect them with job training and helping them find jobs once they're able to work. And some have, they're connected with church communities. Others, they might already have family here. It varies, but.
Is there a translator at that?
Good question. So at the asylum office level, it's the applicant's responsibility to bring an interpreter with them. The government will have an interpreter monitor on the phone that's just making sure that will step in if the interpreter isn't accurately interpreting information, or as a backup sometimes if an interpreter doesn't know a specific word. But it's one of the advantages to the affirmative level, because you can work, you're working with an interpreter that the applicant is comfortable with. So we have a pool of volunteer interpreters. Oftentimes the applicant might know someone. It's really there's a small number of people that would be disqualified from interpreting. We generally try to discourage immediate family members from interpreting for folks. But early on in the representation, if the client needs an interpreter, then we might pair you up with a volunteer and then kind of go from there if it works and is a match. Some clients speak English, but ultimately, in the preparation sessions, we encourage folks to have the same interpreter as the one who's going to be there at the interview, if at all possible, because they'll be familiar. You want them to be familiar with the case so that they know what the applicant's talking about, but you don't want them to be so familiar that they're speaking for the applicant, and in the preparation sessions, that should be pretty obvious, but you know, it's really important for you as the attorney to make sure that the interpreter is there as in that role, and sort of drawing the line when you're in role in the interview versus perhaps some other conversations more informally with the client. And then at the court level, the court has the interpreter there. So actually preparing clients to testify in court, we encourage people to mix it up and have different interpreters, because you won't know who you're gonna have till you're there for the court process. So that in the middle section, it talks about the defensive filing, and that may be, people end up in defensive proceedings if they are apprehended at the border, if they present themselves at the border and request asylum, or if they're referred by the immigration judge. Their case is essentially referred, and the judge gives a de novo review if it's referred. But in the cases where they're apprehended at the border, you're actually filing the application with the immigration court at what's called a master calendar hearing. There's usually a few master calendar hearings to start things off, and then an individual merits hearing is scheduled when the applicant will testify. And that's a more adversarial proceeding. The government has an attorney there, the judge is there, it's in a courtroom, and you can present witnesses. At the asylum interview, it's usually just the applicant, where at the court proceeding, you can actually present witnesses to testify. The government would rarely bring their own witness, but you know, direct examination, cross-examination. It's for those who don't do litigation, it feels much more like litigation. For litigation practitioners, it's you know, much more abbreviated than you know, some more long-term litigation. I would say some of these do go on for more than one day. They aren't like scheduled for a week. They're scheduled usually in 3 to 4 hour slots. If things aren't wrapped up, they might be continued to another day. And then the judges are trying to issue oral decisions. And most of these cases, if they don't, they close the record usually for a decision, and then we'll send out a written decision. The filing deadlines are much more strict in court. For the asylum office, you can provide supplementary information and evidence up until they make a decision. So if you walk out of the interview and think, oh, you know, there's some more information, she seemed to be asking a lot about, you know, this factor, we should provide more information, they'll take it. So that's something to keep in mind.
Sure.
Yeah.
That idea of the supplemental, especially given the backlog, do you think we're facing a situation where we have some supplemental information we want to put forward for interview, and we've already been waiting for quite a long time?
Yeah.
Just maybe pros and cons of the idea of where it's maybe not in reaction to, but you know that we're going to add an affidavit, for example.
Yeah.
The idea of, well, best practice to try to supplement the application more formally through filing the document before, or I guess just pros and cons of that. Do you have any thoughts on that, or the idea of just kind of showing up at the hearing with, hey, here's some additional information you've never seen?
The question is about supplemental documents. If you have them well before an interview is scheduled, should you file it right away or wait until the interview? I think it may depend. I mean, if it's something that you think is, even the facts in the supplemental affidavit could still evolve, and you might be adding another supplemental application, maybe it's worth waiting. But in most cases, getting it in will have it in their file and have the best chances that it would be reviewed ahead of time, particularly if it's something that you want the officer to see. There's a really short window of time between when you get the notice and when they ship the files to Minnesota. So, you know, anything that you try to send them, if you don't make it in the shipment, they would not get until the day of the interview. And if you really want them to look at it before they're interviewing your client, then it would probably be better to send it. I usually tell people to follow up, make sure they got it, make sure it got to the file, and bring an extra copy to the interviews, because anything filed afterwards is a little less predictable in terms of making sure that it gets to the file. So yeah, good question. And then the last section talks about appeals. There's a smaller group of cases that we have, but we do have some circuit court appeals and then some appeals to the Board of Immigration Appeals. After the immigration judge issues a decision, if it's a negative decision for your client, they'd have 30 days to file a notice of appeal, which is not usually too complicated to get that piece filed, but then once the transcripts are sent and there's a briefing schedule, then we'd have time to work on a more extensive brief to argue why the immigration judge got it wrong. So those are sort of an overview of the different procedures. And then there's one other slide that sort of gives you the understanding that the immigration court is part of the Department of Justice. And so both the court and the Board of Immigration Appeals are part of the Department of Justice. But after the board issues a decision, there's no other federal court. Federal courts will handle like habeas petitions sometimes and some other matters, but the substantive asylum claim would be appealed directly to the 8th Circuit here in Minnesota. So, great. So I want to spend some time just walking through the application. So the next few pages has, it's sort of an annotated application. This is essentially, I think there's a more recent version, so we'll be merging the notations, but it essentially hasn't changed that much since the last form was issued. But for the most part, things can be fairly straightforward, but then a lot of times this actually filling out the form can raise different issues depending on the facts of your case. So we'll just kind of walk through and I'll point out some of the different annotations that are here. So you'll see at the top, it can be hidden and I think sometimes is often missed by folks, but this box that just essentially this is the same application that's used for an asylum application, withholding, and Convention Against Torture. And there are questions that throughout that address the different forms of relief, but checking this box would indicate that someone, in addition to asylum, they'd also want to be considered for withholding and CAT. Again, it's only the immigration judge and the board that would be able to grant either of these, but usually if they're at the affirmative stage, it doesn't hurt to preserve that from the get-go if the facts support it. The alien registration number is basically the file number the government would have. Not very many. The applicants that come that are in the immigration system already, that are defensive applications, they'll have an A number. Most of our affirmative applicants, just because you get a visitor visa, that won't get you a file number. So oftentimes there's going to be unassigned or none at the point that you're filing the application. And then once the receipt is issued, they'll be assigned an A number. And then that's going to be the identifier you want to make sure is listed on any subsequent information you're sending to the government. Social Security number, sometimes maybe students, if they're authorized to work, would have one, but most of our applicants wouldn't have a Social Security number at the time they're filing. The name can usually be a pretty straightforward issue. Sometimes though, there might be inconsistencies with different documents that can cause some problems. For folks, we try to flag those from the beginning, but for the most part, people are going to have passports, and that is the name that would be their legal name. Certainly, you can list and the other names that you've been known by. If there are any other documents that have their name, or even if they have nicknames, you can list those there. Or if they've used some other name for some other purpose. This might be come up with some of our clients who've been working without authorization and have used some other name. That would be all examples of what other names might be listed. But really trying to be as consistent as possible with the documentation that they have, the official documentation that they have on their name. residence in the US, like actually where the person is living, and the mailing address may not be the same. I know a lot of clients want to use our address, or want the attorney to just receive the documents because they're moving around a lot. But the asylum office has a policy that they need to send. They can't send everything just to the attorney. They need to have somewhere to send the decision to the applicant. So to the extent they have some PO box, or somewhere where they know that address is going to be, because maybe it's like if someone at their church or something can receive it on their behalf. I mean, really, they send them a receipt, a notice to get fingerprinted, and then the decision. Other than that, the asylum office usually isn't sending them much information. And anything that they do send the applicant, they should be sending a copy to the attorney too. So hopefully that can be cross-checked. But anytime the applicant is moving for purposes of the mailing address, they have to submit a form with immigration. You can do it online, like the broader immigration USCIS system, and then we'll usually send a copy of that to the asylum office so they're updated about the client's address, so that they do get notice when they're interviewed. Let's see. Oh, and then marital status. This can be important as it relates to the substantive claim, as well as to whether or not dependents, a spouse dependent may be eligible for asylum. So, a client may say that they're married, but in fact, they never went through a legal process. But the standard is whether or not the marriage is legal in the country where it occurred. So if you can establish that, then they can mark them as married, and they could potentially be a dependent and receive asylum as a dependent. But that's, usually if someone asks or states that they're married, we'll kind of go through a little extra questioning to make sure, if they have the marriage certificate, all the better. But identifying that from the beginning is important. The date of birth, this also comes up sometimes if the client's insisting, well, my birthday isn't right according to the passport. I think that it's a really hard, we have issues with people even getting work permits if their birth date isn't the same as it is on their passport. To the extent that they're able to remedy, I mean, with some cases, particularly if the government's persecuting them, it's really not a good idea for them to go ask for their government for a new passport. But if it's a non-government actor, it might not be as much of an issue to get the passport modified to correctly reflect their birth date. But anytime you have inconsistencies with the name and the birth dates, it's usually going to add some complications later. So the next 13, 14, 15, 16, these are all, somewhat identifiers, but also is going to be relevant potentially to the substantive claim. So you want to make sure that those are lining up. And then, anytime that it seems that the applicant might have another, be a citizen of more than one country, that is a red flag, because they essentially would need to establish asylum from both places, because if they fear returning to one country, and there's some people that are citizens because their father was born in another country and therefore they're citizens of that country, well, then they should be going back there, is sort of the opinion of the government. So if any of those issues come up, we'll usually ask clients, where were your parents born? Is there, to see if there's any reason to believe they might be a citizen of another country. The proceedings, so there is a difference between when did you last leave your country. Sometimes people that are coming in by plane, the date's gonna be the same of when they left the country, when they came to the US. Folks that have come up through South America, their dates can vary widely. And there are some people that may have been in other parts of the world. I mean, knowing where your client was between when they left their country where they fear return and when they came here, just sort of, screening each of those places and figuring out, is there any reason to think that they were firmly resettled there? If they were there and they had no authorization to be there, it shouldn't be too much of an issue. But a lot of times, asking these questions, these things that may not have come up before, might come to light and are worth sort of integrating back into the substantive claim analysis. The I-94 number, in some cases, they get this little white card that maybe you've seen when you're on the international flight. They've shifted to more electronic version of these, which you can look up and you can actually get a history of someone's travel history. The system's a bit finicky in terms of if the spelling is off by one letter, you're gonna get no results. Sometimes if they don't have the card and for some reason they can't get the information online, you can put unknown. It's not a critical piece, but it's something to provide if you have it. And then other multiple trips to the United States. Is the last entry, is that the only time you've been to the United States? And if not, figuring out, when were the dates, and then how does it factor in to the claim? Because if they had come to the US and went back after the incidents that are the basis of their claim, there may be some issues there in terms of going back and after they are supposedly needing to flee the country. Date status expires, for most visitors, they're given 6 months. For students, it's marked as duration of status, so as long as they remain in status with the schools and such. The one thing to keep in mind is the actual visa foil in the passport has a date when the visa expires, but that's different from the actual stamp they're getting when they come in. That's their status. The visas, the visa expiration is basically saying you can use this visa to come into the United States up until this date. But once they enter, they get a stamp in the passport that says, okay, you're authorized to stay in the U.S. until this date. And standard for tourists is 6 months. It may vary a little bit depending on, we've had some that are a lot shorter because they're here for a specific conference or whatnot. But looking through the passport will hopefully get the answer for that. And usually we provide that information for you too. Travel document information, the client's first and best language to be indicated. Marking if they're fluent in English, that may evolve over time. If you mark no and then submit an affidavit that's all in English, there's usually sort of questions about, okay, how is this in English? So, make sure you're sort of including in the affidavit if there were an interpreter used, and how the information came to be in English on the actual affidavit is important. And then other languages, maybe there'll be none, maybe there'll be 5 or 6 depending on the client. Yeah.
So, when you said actually fluent, a tutor or some, I've helped a couple of and their English are not really fluent, but you can understand everything they're trying to say. Would you consider them as fluent versus?
Yeah, I think if you mark yes, they're gonna expect that the person's gonna be able to go forward in the interview in English. So, yeah, I think you can certainly make the argument, yeah, they're fluent in English, but they're much more comfortable in their native language. But, it's sort of, when you're filling out the application versus when you're preparing for the interview, it may be a different situation too, depending on how long it takes to be scheduled. I think the other thing too is that someone might be fluent, but, with the stress and everything of the interview, they're gonna feel more comfortable in their own language. But to the extent clients are able to go forward, I think it can make it easier and sort of eliminates, on the one hand, having an interpreter gives you a little more time to think about the questions, the responses. On the other hand, it makes it a more indirect communication with the adjudicator, which can be more challenging too. So, yeah. Okay, so the next page, it's asking about family. So are they married? sorry, this is the copy made it a little hard to read, but, so usually we're erring on the side of listing, the spouse, so, you know, particularly if it's someone that the client wants to benefit. On the one hand, one that they want the benefit of being a dependent applicant because, you know, if it's a traditional marriage or, you know, they do have a subsequent legal marriage, all the information is already there. Or if there's some argument that it was legal in the country where it occurred. And then also if, you know, if it's a domestic violence case, having information about who the abuser was is important. Well, I mean, I think sometimes it would get a little complicated if they're legally married to one person, but then they were separated and the abuser's actually, you know, someone else who's not there. I mean, certainly keep that in mind and, you know, providing accurate information here, but providing that explanation of how that makes sense in the context of the claim is important. And then including the marriage certificate and the birth certificates of any children. So there's a different process. If the client's spouse and children are here in the United States, you can file dependent applications. Essentially, that's a copy of your client's application, and then you put the picture of the spouse or child on there, and, you know, send in this additional copy. If they're outside of the United States, you don't have to provide any of those extra copies. There would be another paper application that you'd have to file later for them to benefit, but it'd be important to include the information about where they're at. And really going through and making sure you're checking all the boxes. You know, there's a question that asks if they're in the US or not. We've seen some applications be kicked back because that box wasn't checked. Usually for purposes of the one-year filing deadline, if it's sort of this clerical error, they'll view it as an exception, but to the extent it's possible, you know, going through and putting some response in each of the areas is important. And then also with children, listing all the children, living or dead, biological, step, adopted, maybe customary adoption. It might be helpful to include, you know, right in on the side if it's not a biological child. Adopted children, it does, it's much more challenging for them to receive benefits as a dependent. If your client does have some customarily adopted child, to the extent they're able to get a legal adoption prior to the grant of asylum, that's gonna make it a lot easier for them to reunite with those kids. So that's sort of another thing on their list that they probably don't want to worry about, but to the extent they're able to make headway on that can be critical to the reunification process if they're separated. And then again, if it looks like there's a child that's turning 21 very soon, in order to preserve their eligibility as a dependent child, the application needs to be filed before they turn 21. So it's in some cases they need to meet the qualifications that were filed, and then in others before it's granted. So it sort of varies. But if there is a child, we try to screen for that at the beginning, but if it comes up, you know, just flagging that so you get the application in before the child turns 21 preserves that possibility. And then page 3 talks about married children wouldn't be eligible to come as derivatives, but they certainly should be listed anyway. And always just sort of cross-checking, how is this fitting into the story? You know, where did they say the child was born? You know, particularly if it's with the facts, does that match up with where the client said they were at the time? If not, is there some explanation? You know, sometimes it's like, well, they were born there because that's where the hospital was, even though I live, you know, in this other rural part of town. But really trying to figure out how does it all fit into the timeline and the constants of the substantive claim. Page 4 is usually can be really straightforward, but I would say in most cases it's probably the most complicated one for the clients to put together, particularly if I mean, it's very, it's very much viewed through the lens of US culture and sort of what was the name on your house that you lived. Well, that's not how it works. So the important part here is that it's accurate of what the facts and the reality of the client. I mean, I've had some clients that they can't get any more specific than, you know, I lived with, you know, Uncle or whomever, and that was sort of that was as much detail as we could provide, and, you know, such and such a town, and, you know, estimating what the time was, because I mean, it's key to, it's more important that it's accurate and consistent than overly detailed, I would say, in this section. You don't want to commit your client to facts that they're just not going to remember when they get to the interview, and particularly with, you know, some of our elderly clients or those that are illiterate, these can be really challenging. But just trying to frame it into what they can remember is important. And the asylum officers often, these first few pages, they kind of quiz them about, you know, where was this then? And not in sort of an adversarial way, I'd say. I mean, I think it is in somewhat to test their credibility, but also just to kind of get it as accurate as possible and sort of warming the client up through what should be pretty standard questions. So in the first section, they're asking for the actual last place that the client lived before they came to the United States. Generally, there's, it sort of varies in terms of length of time, and, you know, when do you consider that I actually lived in this place versus I was traveling through. I sort of work with the client to figure out what makes sense. I mean, sometimes I'll even put, like, clients that were in a detention facility, like, for a month or something, we'll list that as the place that they live, because that sort of fits in the chronology where, you know, others, they were actually living somewhere, but they went on a trip for 3 months to wherever. But, you know, kind of, again, working it back into the timeline of the client. But they want, you know, the last place that they lived, even if it was another country. And again, okay, they say, South Africa, did you have status there? Were you living there legally, whatnot? And then the last place in the actual country from which they're fleeing. And then look at the sections that ask about where they've lived and where they've worked. They only ask for 5 years. So if it's challenging for your client to remember dates of places, just stick to the 5 years. But sometimes clients, you know, it might be relevant to their story to know where they are and helpful for them to sort of describe all the places. I mean, you can go further back than 5 years, but they're only requesting a minimum of 5. With schools, you know, if they remember primary school, we'll put it on there. Sometimes they will ask about that. And then for employment, you know, if they're working without permission, including that is still important regardless. And then the last section asks about parents and siblings. To the extent they remember all the names of their siblings, you can go on a supplemental page to list everyone. Anyone who's not, you know, and this also screening, like if they're saying, I fear persecution because I'm a member of a particular religion, as is the rest of my family, and the rest of the family is living in the country, then, you know, there needs to be more questions about that in terms of, well, how can they be safe and you can't be, or, you know, maybe they're all living in hiding, but addressing that. And then any family members that are living outside of the country, you know, there may be a bunch of siblings living in another country and they received asylum on the same basis the applicants seeking asylum, so that can be important to note. And those that are living in the United States and have any status, if any of them are citizens, they file petitions for the applicants. It will be decades before they can benefit from it, but it might be relevant. Or if they received asylum, in many instances the adjudicators might want to see that application if it's on a similar basis. We've had, I think, one where the officer asked about it, but the sibling's application was not related to what hers was, and so she wasn't really interested. But being familiar with that, and then, you know, if they've got half siblings and things, listing that to the extent that they, yeah.
Is there confidentiality that was when it's going to sell? So for example, if you're telling me that you're working for this spot that you see Fox Construction, is that information shared with Fox Construction now? Would they that information be shared with some other agency that will let Fox know this person?
So generally, you know, at the beginning of any interview, the asylum office is telling the client that this is confidential. I think in most cases, the fear of the client is that they're gonna go back and ask the home country, and that's a definite no-no, but like if they're in removal proceedings and, you know, there's a whole disclaimer at the end of the application that, you know, you're sending this and you're telling the government you're here, and, I mean, there's nothing that would stop the government attorneys from going out and questioning them. The odds of it happening, I would say, are fairly slim in most cases. I don't think I haven't seen that be an angle that they would go after clients on yet. And in this context, in the context of an asylum thing, if it's, you know, if it's someone who's adjusting status, becoming a permanent resident based on marriage to a spouse, that is a big issue, because if they check the box saying they're a U.S. citizen, then they're barred. But at this stage, that I would say that's not really likely to happen, but good question. And then starting at page 5 is when you get into the substance of the claim, checking all the boxes that might be relevant, including if there are multiple grounds, and then answering the questions that some folks prefer to say, you know, in the box see supplement and not really answer any of the questions. Our guidance is usually to put in sort of a succinct summary that fits into the box. You can run on to other pages, but usually our recommendation is, you know, to include a summary that fits in there and then say refer to the affidavit for further details. I would say most of the officers, they get through page 4 and then they're turning to the affidavit for most of the information. But, you know, questions A and B is sort of the crux of the claim. Have you been harmed in the past, and do you fear harm in the future? And that's going to be the bulk of what we're going to be talking about in terms of the claim. And then the rest, and then the other pages, you know, part B, asking if you or family members have ever been detained. This is other than the United States. So a lot of times if it's a political opinion claim from Ethiopia and then if they've been tortured in detention centers there, yes, I have been, and you have an opportunity to explain the facts of their detention. 3A and 3B both go to the substantive claim in terms of, you know, if they belong to a particular social group, or yes, I belong to this religious group, but it's, you know, in the home country. Yeah, in your home country. So, you know, sometimes we have clients who get involved in things once they're in the US. The question doesn't specifically ask about that. When it's the client and family members, and sort of generally described in some of the questions they ask, you know, have you, your spouse, your children, or you, your spouse, your parents, or siblings. But, you know, this says family members, which seems you can define it sort of loosely. I would say to the extent it's helpful to include it, you can, but, you know, if it's like my second cousin was, you know, if it's, my second cousin was also involved in the political party and, you know, had this position and is now has asylum somewhere, sure, include it, but, you know, if it's some distant family member and the fact isn't really helpful or relevant to the claim, there wouldn't be a need to include it. Because the other thing they use it for is to also screen to see if they were part of any terrorist groups for purposes of the material support bar. And again, you know, with all of this, if there's additional information that comes up before the interview, you can make amendments and add things to it. Question 4 is actually, you know, specifically to the Convention Against Torture. And, you know, if they fear that they would be tortured by the government, or, you know, also including if I mean, the standard is, will the government turn a blind eye to someone else torturing them? So including that as well, you know, if they aren't fearing the government as a persecutor, do they think that the government would allow the person who's gonna harm them to torture them? Then in part C, this is where they're sort of asking about and they specifically include spouse, children, parents, and siblings ever applied for refugee status, asylum, or withholding of removal. So, you know, other family members' claims would come up here. In the next section, they ask, you know, after you left your home country, did you travel through or reside in other countries? I'll even go to the extent of putting, you know, if they had a layover somewhere, but just saying, you know, as a layover, it was, you know, 5 hours, I never left the airport, wasn't able to stay there any longer. It might be a longer answer if someone's traveled up through Central America. Sometimes clients don't even know where they were, but can kind of give a general path. But again, to the extent that they can recall, and, you know, using that qualitative language of, you know, I think we went through here, but not having them beat themselves up too much if they're not recalling. But I would say most clients do have a general sense, even if they've traveled through multiple countries. And then, you know, if they have been somewhere and they have lawful status, that question of firm resettlement, well, you know, how long was that status for? Was it temporary? Could you go back there now? Or has that status lapsed? And then question 3 is to the persecutor bar, have you harmed anyone else? And if they say yes, call us, because that can be an issue that we should have flagged before if it's a surprise. After you left the country, did you return to that country? And this question, it's sort of the last time that they left, I guess. I mean, sometimes people, you know, if they are a student and they come here, I mean, I think some folks would say, okay, since your last entry to the United States, but I think probably they're more sort of interested in after you fled the persecution, did you ever go back there? I mean, sometimes we have folks that leave the country and then they have to, you know, make quick trips to go get their visa, or, you know, there's some minor trip that happened, but, you know, trying to understand what the consequences or the context of the trip back was, and sort of framing it, but knowing that I mean, that's gonna be an issue. Do they, was it safe for them to come and go? And, you know, at the border, you're fearing the government, but did they inspect your passport? And, you know, really depending on the context of the country, I mean, some places the borders are very fluid and really no one's checking anything, and other times, you know, if you're flying in and out of an airport and you're going through customs and things, there might be more issues there. The question 5 asks about that 1-year filing deadline. If it's after a year, I mean, usually with those cases, they've been flagged for you to know that that's an issue. In most circumstances, it's going to be no. And if not, explaining the reasons. And then the last one is if you've ever committed crimes here in the United States. And again, we screen for that, but if it turns out that your client did have contact with law enforcement after your case is transferred, certainly give us a call about that. And then the final page, you know, there's all this disclaimer information, a warning about filing a frivolous application. You want to make sure that you go through and explain all of these to your client. You know, we meet with them multiple times before that we transfer a case to a volunteer, but it always is important to kind of go through everything multiple times and explaining that, you know, if it's an affirmative application and if you're not in status when they make a decision and they don't grant your case, they're going to place you to removal proceedings. And if the facts that you list here are based on information that's not true, you could be permanently barred from any form of immigration relief. So it's sort of like this is your last chance to back out, because once we send this in, it's going to be in the file. So, and then there's, you know, printing your name in a native alphabet, particularly if they're not Roman letters. If other people, you know, usually it'll be no about parents, spouse, or children helping you application, if you, the attorney, are helping them. If someone else filed yes, and then, you know, including your information in Part E. Maybe represented by counsel. This is usually this next question about, have you been provided with a list of persons that can assist you when people are apprehended and they have a defensive claim, they're given a list of free legal services, and so, you know, it's sort of that check. Did you have the opportunity to try to get legal representation for your case, and, you know, either didn't qualify or didn't pursue it, indicating that there. And then the applicant signs on this page. The page 10 is not signed. The Part 4, they'll sign after the officer may make amendments at the interview. If it goes to the immigration judge, that's when they'd sign even more amendments perhaps in that Part G. And then the following pages are for more children if necessary, and then the back page is if there's, it's sort of a free form, whichever sections that you need to add more information to. But that's essentially the form of the asylum application. Are there any questions about that?
Yeah, this form says it expires in 2007. Is it relatively same now, or?
Yeah, it is. Yeah, we just haven't transferred this nice annotated version, but it is essentially the same in terms of how, you know, the annotations being helpful. Okay. So the next piece I want to talk about is the affidavit and the supporting documentation. So in the packet, the next page has this sample checklist of issues, and then there's a sample affidavit. This is actually, agency this comes from, but I mean, it's listed for Jamaica, New York. I mean, generally you're gonna put information Chicago Asylum Office, or, I mean, they're not really strict about the form. I mean, generally, if your client's gonna sign it before a notary, it's an affidavit. If it's not, you know, you have to get it filed in, and there's no notary available, it's a declaration. So, but including the language about declaring under penalty of perjury is important. And then it really sort of varies in terms of how long they are. I would say most affidavits are probably at least 7 to 10 pages, some maybe much longer, some shorter. But what we have on the screen here, and then the handout kind of gives you, I mean, every case is going to be a bit different in terms of how much background you really need. But the adjudicators are most interested in, you know, how did you become a part of this protected group that you're a member of? You know, how did you, you know, did you grow up in the religion you're in, or, you know, maybe someone who's converted to another religion, or how did you get involved with this political party, or whatever the protected ground is, sort of that background. I mean, it may be important to give a context of different family members. In some cases, it might not. But, you know, the basic information about when, where were you born, etc. And then sort of developing those facts. But really the heart of what the officers are going to want to see are, you know, the details about the incidents of past persecution and that future persecution. In terms of of all of it, really working with the client, what we do before you have the case is, you know, we've met with the client multiple times. They usually come to us with we ask them to bring a personal statement, so that's sort of a start. And then we provide you with a write-up that's usually a compilation of information from the personal statement from multiple interviews we have with them, and then we might have some follow-up questions, and that's all integrated into this case write-up that you're provided as really a starting point. I would say if they have a personal statement, like, that's the information that the client came to us with. That's what we know for certain is what the really heart of the claim and what was front in their mind. And then the other issues may be things that they may not have been aware of, or, you know, just more details drawn out. But the affidavit is, the purpose is to, you know, really lay out what the claim is, so the adjudicator can understand it, and then they often use this as sort of cross-checking the client's credibility. So it's important to have enough detail to really sort of lay out the claim, but not too much detail if it really was hard to get those details out of the client, if there's a chance that they're just not gonna remember it the same way once they get into the interview situation. So, you know, usually the preference is having, you know, a chronology of events. We have officers that just sort of jump around everywhere. I think for us, it seems to make sense to do chronology, but for clients, it may not always make sense. Or, you know, we want all these dates to line things up, where for the client, it was, you know, the first incident happened after my child's 5th birthday, or you know, there's some agricultural season, or whatever it is that the context of the client's memory is what you really want to be true to. So sort of finding that medium that's going to make it clear enough to the adjudicator, but true enough to what the client remembers. But really trying to hit on all of those elements. You know, what is their identity? What's their how do they become a member of this protected group? How do they come into contact with the persecutor? And then, you know, the incidents of persecution. With some, you know, political opinion claims, facts often line up with the way that the election cycles work. There's usually an uptick in violence and detentions, and, you know, getting that information from the client of when things happened, and then looking at your country conditions too, because, you know, you want to make sure that the consistency is not only internally in between what the client has written on the application and what they're saying in the interview, but they're also looking at, you know, what do the country conditions say. If they said, yeah, I was, you know, detained after the election 2007, and you look at country conditions, there was no election then, or for them to be specific, if it was some local election or what have you. But trying to make sure that all of your information is adding up. But, you know, detailing what happened in the different incidents, and then what happened after. Was there medical attention? Did they seek government protection if it wasn't a persecutor? But, you know, sort of getting through that chronology. If there are big gaps in time, finding out what happened. I mean, a lot of times with political opinion cases, there might be you know, some extensive detention, and then there's lots of surveillance. They have to go do check-ins, or, you know, people would be coming to their house and making sure that they were compliant. Maybe they really went undercover. They didn't. They weren't active because they were, you know, whatever torture tactics the government used were effective because it essentially silenced them. But in fact, they don't want to be silenced. But really trying to figure out, is there a flow to the events? Are there any gaps in information? And drawing out the different pieces of the claim with the client. And then also that period of the flight, and how did the client get out of the country? Did they get a visa? Did they need any help in trying to get that? When was the passport issued relevant to the incidents? And then their actual departure, particularly if they're going through any airports and the government's the persecutor. Once they were in the US, have there been any follow-up? Is anyone still looking for them? Do they have contact with family? Is family safe? Any internal relocation too prior to them leaving the country? And then the current situation, are there any changes in country conditions that might be relevant to the situation? You know, particularly with the political opinion claims, that can be really important if there's all of a sudden change of power and the group that you were involved in is now part of a coalition government. That needs to be addressed. But really, it's very fact specific, but these are sort of the different pillars that will be part of the application. So there's an example here of an Ethiopian claim. And again, you know, using what I usually tell people is in the affidavit, the hope is that you can extract, you know, use subheadings, and you can extract the subheadings, and that will basically lay out the claim, give an outline of the claim. That should really be kind of a goal. I mean, this one's a little more simple in terms of, background events where, you know, we usually use a little more descriptive information to explain sort of the different pieces of the application, or of the claim. Okay. All right. Do we want to take another break or keep going? I'm gonna jump into some of the other information about country conditions and experts and volunteering. That's a break. Okay. Okay, let's take about 5 minutes and then we'll.
Oh, that's no problem.
This is the one where another turns.
Or you live here and then you go back.
Yeah, I mean, I mean, I think it's relevant if she does have issues. She would be issues. Yeah, yeah, so you want to make sure she's, I would definitely different, yeah. Yeah, and then have
Well, especially since you have a place here too, because you're at the University of Minnesota, right? It's just
yeah, I mean, I would reach out to them and, yes, like Sunday
home on the weekend.
Yeah, I mean, she would have been issued a work. I mean, it's not like.
So I probably
Yeah. Right, well. Yeah, I mean, I would say. Yeah.
And actually,
Yeah,
back when
yeah.
I was the summer associate, there was really no set start.
Oh, really?
And so in fact, I worked till like, okay, I love a week off, but I'll take the first. Yeah, exactly. Very, I didn't have like 10 weeks. Usually there's like a staggered.
Yeah, they have something else. But it'll say, you know, if you're in the country before this date, and you can show up in the office. Get temporary fix it. The idea is that that allows people to be able to work so they can see home. Or, you know, they're better.
There's something to be like, you know, get a recharge. Yeah. So bad.
Oh, no, she. Oh, okay. Yeah, yeah, I know, I see her.
Yeah.
Oh, yeah. Yeah, she was a staff attorney for the women's program. But then the director of the women's program branched off to their own program and
Yesterday.
yeah.
Really knows where to sit.
You were here somewhere,
Yeah.
but I was like, yeah.
Well, I said I put that on.
Yeah, I mean, if it's a published book, or
Oh, really?
but yeah, the immigration judge. I mean, they'd have to file a freedom of information.
So, do your projects come mostly from Central?
Yeah, for the most part. We can do both.
As far as you know.
Just waiting for the snow to report on it.
Projects that overlap. There will be people here. So those.
Yeah, I mean, they scan them in. Yeah, there's. Yeah, the only electronic filing, I think like the government and like the notice of the court, that's the only but, no, that's.
Trying to make sure hit the mark on the project.
Yeah, I mean, even FOIA's, you know, didn't
Well, I
actually
think,
was it
my email about, did you say that you wanted to do a project? See, so, or it was me, I can't even like email back and say after you went, because you can't come, I was like, okay, but actually it worked out just fine, because Dean's wife and my daughter wanted to come, and so it was just perfectly fine, so, yeah. But I mean, it's like, so like, but one of them asked about whether you could do an asylum project or like that. Oh, must have been Kendra.
Yeah,
Oh,
no.
perfect. Yep, okay.
So I was thinking about doing that, and then trying to see the ordinance that was left before I.
Yeah, so it was your email, I just couldn't remember, you both had K names, so I don't know if
Oh,
there's there.
everybody was just.
I'm terrible.
Yeah, and I would say, you know, and I keep doing it.
Or is it policy? Did I send you one that was turning me yesterday? She found out our schedule, she might have moved on. Because it would be one where, like I said, it's just like, you do all of it.
But it wouldn't be like.
So we think we end up sending a lot of them.
So you know, you'd be able to get spam. Some things that started.
You're not the only one.
Well, now I will, now I've actually spoken to you, I think I can remember.
And she actually, I had to take off, she had made a show.
Yeah, yeah.
She's more interested in like if policy and I can answer just deal. You know, with their report today, so she had a report. She couldn't find the
Was she here?
Yeah, she was only here, and she actually had to run that application.
Oh.
And then she's like, no.
Well, I mean, this is material, maybe that's what I've done.
Yeah, I think that'd be
Many
one
of these, but just, yeah.
Yeah, this is, I mean, this is really good. Great, nice to meet you. Okay, so, so we've got a couple, 2 pages, as we call them. One on country conditions and the other
Got 2 more
on
months
experts.
to try.
So in addition to this form application and the affidavit, a lot of the work, and I find it to be some of the fun work to kind of look at what's out there in terms of country condition information. The only thing that the court has said they will not accept is Wikipedia. Everything else is taken. And as the judge say give it the weight that they deem appropriate. But you know, there are certain guidelines in terms of what's going to be given heavy weight. Certainly the most weight any adjudicator is going to give anything is the Department of State report. So that should be your starting point. When we transmit a case, we'll give you a sort of background information on the country and then information that's specific to the actual case that you have. And then some citations for different places where you can find that information. So that can be a good starting point in terms of documentation. But you know, it really depending on the topic. There are just, and I think with the internet now, I mean, we used to keep these files of newspaper clippings, and we had volunteers that came in and did the clippings, and we had them on each country, and now it's a lot easier to find information. But depending on the claim, sometimes we've got pretty developed lists of information. We have sort of a template table of contents for Ethiopia, because we get a lot of cases from Ethiopia. But for other countries, you know, just doing standard searches, Amnesty International, Human Rights Watch, some other organizations might focus on different areas where they report, I mean, female genital mutilation, there's a lot of documentation and really comprehensive reports on different countries. So really, you know, providing information, as I said earlier, to the extent you're able to break it down and help the adjudicator see how this information is relevant to the claim. I mean, they generally, and the court will want the full copy of whatever it is that you're filing, even though a small section is gonna be relevant. They tend not to want excerpts because they don't want you, sneaking and hiding, not including things that could be damaging to the case. But that is important to keep in mind because, usually if there's a document that there's, 75% helpful and 25% not helpful, if the judges want to grant the case, they'll say the 25% of that document. So maybe try to find that 75% of information somewhere else. But it's sort of your choice of how much you want to include. I mean, there can be hundreds of pages of supporting documentation. I would say if the human rights report from the Department of State is very specific and very strong in terms of your claim, you probably won't need as much additional information. If it's not that helpful or it really doesn't speak to your issue, then you really want to try to find sufficient documentation. Sometimes it's going to be very specific, like for example with FGM, it's a specific tribe in a specific country that practices in finding, okay, this statistically this is what happens and this is the type of FGM, and to the extent it's consistent with what your client is saying is important. But it really sort of varies on the case. It's also helpful to highlight, just drawing attention to the adjudicator. There isn't really a formal way. Usually it's not good to editorialize and write comments about how it's relevant, but drawing their attention to what you think is important to the case. They're always going to read everything, but it is helpful to them to point out what they can cite to in order to support the claim. To the extent possible, legal briefs are helpful, and that sort of helps you incorporate a lot of the country condition information. I would say not all the claims require it. If it's your first case and you have the time for it, I think it's helpful to kind of walk yourself through the claim and make sure that each of the elements are addressed and you have documentation to support it. Yeah.
Thanks, Sarah. On the affidavit, page 11, they're calling attention to when they sleep in bad nightmares. So would you be able to establish a well-founded fear by using some of the elements of the emotional distress claim, like if they're having recurring nightmares or visions, and to see how we can establish that?
Yeah, good question. So, and that somewhat relates to some of the experts, but in addition to experts on certain countries, there's also mental health experts that can also be helpful, like the Center for Victims of Torture, and there's some other great organizations that are familiar with asylum seekers that can provide that documentation of sort of the ongoing harm and establishing sort of an objective assessment of different psychological symptoms that someone might be having as a result of their experience in the home country. So that is a good point. So we have another example here of a table of contents. This is actually a sexual orientation-based claim out of Jamaica. So each client's going to be different in terms of how much primary documentation they'll have. Do you have a question? Yeah. Yeah. Well, it'd probably be separate. Sometimes they'll be, I guess it sort of depends. I usually, you can wait till you have the legal brief and everything all tied together before you file the claim. But given the weight for a lot of these cases, if it's going to add much more of a delay, you might be doing the legal brief after you send in the application. Yeah, because only after the application is filed does the client start accumulating days in order to get the work permit. But just before the table of contents, because usually you have sort of the cover letter that says here's the form. There's also this notice of appearance form that you submit with the application that says that you're an attorney in good standing and the client wants you to represent them. and then the affidavit, some people will put the affidavit within the table of contents, but we usually will just put it listed in the cover letter after the application, and then the table of contents, and then it sort of goes, you can frame the brief as sort of the cover letter if you're submitting it with the actual application. Great, so in terms of primary documentation, your client may have a lot of documentation or they may have very little. You know, I would say, for example, our clients from Ethiopia usually have very little primary documentation in terms of, I mean, maybe there'll be a party card, but they don't have a lot, like their check-in and check-out date from the detention centers where they were tortured, and but there's often a psychological assessment from CBT, but it's sort of, the case doesn't, the more primary documentation you have, the basic standard is if it's reasonable to corroborate some part of the facts, you should include it, and if not, explain why you don't have it. So, you know, I think in some of the cases, there's sort of this debate about what, you know, do you need an actual letter from your persecutor? Interestingly, we do have some clients that have actual text messages that their persecutors have sent them. So that's sort of an interesting piece of evidence. And I think as technology has evolved, the asylum office is really open to receiving anything. The courts are very reluctant to anything that's not on paper. So we found some challenges, you know, because with all of the Facebook and YouTube and everything, that really gives you some pretty concrete evidence in terms of some of the violence that has gone on. The court is a little more reluctant. We've been doing some experimenting. I'm really excited to see some of the cases challenged on these basis, but not quite yet. And so I would say it is an affirmative case. If they have something, you know, trying to figure out a way to get it into the asylum office's hands. If you can get, you know, if there's a video and there's audio and you can get some sort of transcript, the more authentic the transcript is, the better. But that will sort of better preserve it if it's turned over to the court later. But a lot of times it's going to be, you know, their identity documents, affidavits from family, friends that witnessed things that happened or knew about the persecutor looking for the person after they left the country, might have police reports. It really sort of varies depending on the claim. But maybe that will be up here, or maybe, you know, if it breaks down in terms of different incidents, you could even break down the primary documentation according to that. And then this example at least sort of outlined how Jamaican law views homosexuality, and then, you know, the different types of documentation. There's no set format in the way you have it. I'm usually like, look at the body of evidence that you have. How can you strategically put it together so it will lay out the claim for the adjudicator? But there's no set formula in terms of how you're gonna organize the evidence necessarily. So, and then the other piece are the experts. I mentioned the mental health experts. Sometimes it might really be helpful to have a country condition expert. There are some databases. The ones we've seen, the most developed ones, are actually out of the UK. And that might be fine if you find someone. They don't necessarily have to be in the United States in order to have an expert opinion. The courts generally use, the federal rule of evidence. We have another training specifically on removal proceedings that talks about how the rules are so very different in immigration court. So much looser than those of you that might practice in state or federal court. Hearsay is welcome and relied upon for asylum claims, for example. But generally, they use the federal standard in terms of experts, and are often the most, I would say the most successfully recognized experts are the ones, are academics that study the area of the world that you're studying or the specific issue, and they have publications. In some instances, you might have someone that doesn't quite fit that mold, but if it seems like they do have specific knowledge that's relevant to your case, by all means support it. You would want a CV from the expert, and then we included a sample affidavit that we've gotten from an expert. It really varies. I mean, you want to have a chance to look at it and maybe ask follow-up questions to the expert. We find many experts are very generous and will do expert statements pro bono, knowing that you're representing the client pro bono. Some may ask a nominal fee. We're certainly, there's some leads, and we have volunteers that are very successful in sort of seeking out some experts on their own. We're certainly willing to share if we have leads on any specific type of expert you might be looking for. If you have a court proceeding, the judge, you certainly have a right to have your witnesses heard. I would say our judges tend to be a little more reluctant on having them on the stand and testify. At least one of the judges say, well, if the affidavit is sufficient, then I don't need to hear from them. Fairly reluctant. They may grant a motion for telephonic testimony, but we'll sort of press to see if it really is necessary. But in the cases where we have had a local expert come in, there was a Central American gang-based case that was heard last fall, and it involved a woman who was a part of an organization that supported the police to enforce the law against the gangs. I mean, they did things like, had potlucks and other types of things, but because she was supporting the law enforcement, she was targeted by the gangs. And the judge said in her decision, I came in here ready to deny this case, but largely because of her extensive questioning of the expert, really saw how that did fit within the context of the law. So it really can make a huge difference, particularly with the cases that the case law just isn't settled, or if it's some more novel claim, the expert opinion can really carry the day. So working with them to try to make a strong claim can be helpful, and like particular social group, if it's not an area that's well settled, the expert can really sort of help to frame it because they know the country and they know the context that you're working in. So yeah, in terms of affirmative claims, it's usually going to be all paper-based, and then sometimes with the removal cases, there'd be oral testimony that they can provide. So great. Any questions on country conditions or experts?
Sorry.
Go ahead, Mike.
So for the human rights report from the State Department, is there like a few years old?
Good question. So Department of State reports human rights conditions using older versions. So they tend to come out in March or April. I still haven't seen the 2014 version. I'm looking back to my interns. Have you guys seen them? Yeah, I'm surprised they're not out yet. But they tend to issue them every year. And so having the most current one is important in terms of, changed circumstances and sort of addressing that. But then I also, if there were incidents in the past, it's helpful to include that specifically. I mean, we've had some cases where the client talks about being involved in a specific protest, and that was actually described in the Department of State report. But to the extent that it can corroborate the past events, using the past reports as well as the most current one is helpful. So, I mean, even like this sample expert statement, this was a Guatemalan one, and we used, it was based on facts going back like in the 1990s, and so we found the archives of those ones, which were interesting to see how it's kind of evolved. They used to be much more contested, I think, by other human rights organizations, but now they tend to be fairly good in terms of, if it's not helpful information they provide, it's usually just not there. It's not so much that they're trying to paint a prettier picture than what is actually happening in the country. All right, so I just want to spend, oh yeah, you had a question too.
Can you use, if the
Yeah, in terms of medical documentation about support groups and things, yes, I mean, sort of along the lines of the mental health evaluation, it sort of varies. I mean, if they're already getting, if they're working with Center for Victims of Torture, they sort of know, you know, they have sort of their standard letter that they provide for asylum seekers. If they're getting help somewhere else, it might take a little more education. You know, they tend not to want like detailed reports from each doctor visit or something if there's some medical condition, but you know, to the extent that a provider could provide some sort of letter that would explain what types of symptoms they have, and you know, the ongoing care. I mean, there's sort of this debate with different types of applications even, in terms of what's better. Is it like a letter from a therapist who has a long relationship with the applicant and, you know, sort of establish that their mental health needs are real, versus a forensic evaluation that's done specifically for the purpose of the claim. I mean, on the one hand, the therapist might be biased because they want what's best for the client. And then on the other hand, the forensic examiner, you might just be going to get that evaluation for the purpose of the claim, but you know, if you really needed that help, you would be getting services. So there's kind of a debate on that. We've had some issues with the court. I mean, the Center for Victims of Torture specifically, I think, has had some challenges by the court, but I think overall it usually is very helpful. And I think at the asylum office level, because it's a written letter, it can be really helpful to include that, you know, specifically if the client is having ongoing issues, and may be able to go into more detail than the client could about their own symptoms and things. Yeah.
And along those same lines, do you have to make any consideration for, okay, I'm gonna paper the record at the asylum office, but what happens if this gets to the court level and I can't bring all these people to court or whatever? Like, do you have any concerns about things like that? Or like, should you just go forward and give them everything?
Yeah, I mean, if they don't get referred to the court, all the better. Yeah, you know, I would say bring up what you have. I mean, the case is reviewed de novo by the court, and they know that, you know, you have an expert that submitted a statement and it's been forwarded to the court. You know, by the time the court is hearing it, the circumstances may have changed for that. I mean, they're not expecting that person necessarily has to show up at that level. And I would say the court, at least currently, is, you know, happy with the paper version. It would be less time for them. I mean, I'm surprised that the government hasn't raised more issues because of not giving them a chance to cross-examine them, which I think would be the whole purpose to have them, you know, or, you know, one of the reasons to have them actually testify. But I haven't seen where, you know, there's this expectation because you filed a written affidavit by an expert with the asylum office that the judge is expecting them to appear at the merits hearing, you know, years later, so. Okay, all right. So I just want to talk briefly about, I'll just briefly talk about this. During the asylum process, people are legally allowed to stay if they're not in some other legal status. There isn't like an asylum seeker status formally, but they get a paper saying you're allowed to stay in the United States while your case is being adjudicated. We have seen some cases where applicants have filed an affirmative application, their visitor status has lapsed, and for whatever reason the government is interested in them and brings them into questioning and they're placed in removal proceedings. There's certain arguments to try to say, well, just let the asylum office decide and then they'll be back before the court later. Quite rare, I would say, but can't rule it out. So we usually have that discussion with folks ahead of time, but you know, that's sort of important to keep in mind. And then eligible to work. So when they get the receipt, it says your case has been pending as of this date, count 150 days, that's when they can send in the asylum application, and the office is supposed to issue the work permit 30 days later. That's how it's supposed to work. And they renew every year while the application is pending. There's different considerations when it's before the court. There's this asylum clock, and actually there's one with the affirmative office too. So for example, if you're, there's so much of a backlog, we rarely see it happen, but let's say the applicant files the application, they're scheduled for an interview 30 days later and they ask to be rescheduled. They'll reschedule them, but they stop the clock. so then their clock won't start again until they actually show up for an interview. So that can affect their work permit. If that happens for some reason, it's worth discussing with the client, like and figuring out the situation. Does it really make sense for the client to forgo the work permit in order to delay the asylum interview? And then we are happy to provide social service referrals, sort of those other support things as clients need them throughout the process as well. This is a violation of the PowerPoint rules. It's a lot of lines there, but there's a handout actually that might be a better visual. This one that says case placement and training client roles. And that sort of explains how the relationship works between all of the actors. So, at our level, we screen the cases, we do preliminary background research, and place the cases with a volunteer. We oftentimes, particularly if it's your first case, will pair you up with a consulting attorney. We're always available to answer questions, but we do work with some immigration practitioners that do a lot of asylum work, so you've got another person to work with, and they'll be more, they'll get a copy of the file and be familiar with the case, and you can use them to review your application and affidavit and answer questions as you go along. And then the client, when we meet with clients and we tell them that once your case has been transmitted to the attorney, the volunteer attorney, that's your main point person on the asylum application. Feel free to call us if you need social service referrals. We really encourage them, if there are issues with the volunteer, to work it out with the volunteer, but you're both able to call us so we can try to figure out if there's a remedy, or if it just isn't working and there might need to be a placement switch, what have you. And ask the clients to keep us updated about their address and phone number so we can contact them, and make sure that they're complying with the requirements of updating the government. And then the volunteer attorneys attending a training, check that all off. And then we'll get those that have signed up. We have a monthly, it's called Asylum Updates, and we have information about upcoming trainings. There might be information about, like there was temporary protected status issued for countries affected by the Ebola crisis. And so if people had been in the country since November 20th of 2014, they could apply for that. So we let attorneys know that. Usually clients are pretty aware of that alternative relief. It doesn't mean that they need to withdraw their asylum application, but it's an actual status they're able to pursue. So different updates like that, or if there's some big case that is really important for everybody to know. And then we also do that's how we communicate the available cases. So there'll be short summaries of different cases. They'll say, Mr. Liz M or whatever from this country, and then there'll be a paragraph or two that's describing the claim. And then the hope is that the volunteers, you'll look through that, and if there's a case you're interested in, let us know. And then from there, we would send you the case write-up and other information to kind of get you started in working with the client and give you the contact information. And then I would say volunteers really vary. I mean, some volunteers are really independent and go on their own and don't need us that much. Other times, are in touch with us or with the consulting attorney. Sometimes they'll send an email both to me and to the consulting attorney, whoever can get to it first. And so that's, our hope is that you've got tools and with the information we provide you, what's here, what's on our website. There's another probono.net website that has resources, and then let us know whenever you have questions, and we're happy to provide as much or as little support as you need. And then the consulting attorneys. And really, our hope is if it's your first case, have your consulting attorney look through everything and, before you send it off to kind of give it a once over. So, and then periodically we'll check in with the volunteer and with the client to see how things are going. And then we ask that you let us know. We usually like to know before an interview is scheduled so we can help provide any support that's needed. And then when you get the decision to, so we can keep our records updated. And then in addition to you sending a closing letter to the client, we also send information. I mean, if they're referred to the judge, you know, we'll put them back into our deliberations process and see if we can continue and work with you on that, and if you want to continue. And then if they're granted, give them some information about, well, what's next, and what can they expect, and when can they apply for permanent residence, and all of that information. So this is just a list of some of the resources, the manual on our website, probono.net. And like I said, we have ongoing trainings. We're actually in July, there's a training we're doing with the Center for Victims of Torture on working on sort of secondary trauma and working with torture survivors. We're there to support consulting attorneys. The interpreters, there's a spot on our website where you can submit a request for either documentation translation or an interpreter. And then you send that in, and then we'll send out a call to our volunteer interpreters to assist with that. And then there's also on the website, there's a case update and case closing online form that you can submit. This is just a screenshot of the probono.net. You have to, it's password protected, so you have to set up an account, and then we'll activate you and you can access their samples and other information. There's quite an extensive library, and this is a collaboration with a bunch of organizations throughout the country, so it's a national focus, but that's, so it's quite extensive in terms of what's up there. And then this is our website. I was gonna see, I don't know if I can click on it. I don't know. I was gonna try to click on the page, but I couldn't figure out how to do the screenshot. But on this page, there's the actual sign up. So you can, do you know if if I just go to the the internet?
I'm not sure, just give it a shot. Looks like it's working.
Okay, oh, it's very tiny though. So there's a couple links here. If you go to our website and there's a spot that says pro bono attorneys, there's a place to sign up as a volunteer. We have a volunteer agreement that you sign. Those are sort of the two things we need after you've done the training, before we can transmit a case. And then also, if you do take a case with us and you send us a copy of your retainer, you'll be covered under our malpractice insurance for that specific case. I know that's depends on where you're at in terms of whether that's a need for you or not. And then some of the other resources are here. We also have in addition to the live trainings, we have some trainings that we've recorded previously, and you can access those. There's some webinars we've done with some national audiences too. But there's a lot of different resources in person, remotely, as it best fits your schedule. So, great. Well, are there any other questions folks have about volunteering? I think what I'm going to do is I'll send you all, we created this survey that we've just tried this year to match folks up, and it makes it a little less work to have to wait for the monthly email, but I'll send you a survey that'll kind of ask about your interests, if you're interested in volunteering this year, and try to pair you up with a case that might fit your interests and geography, type of claim, language spoken, what have you, and then can reach out with cases that we have that might be of interest if you're ready to volunteer. So, well, thank you all for coming. Do you have questions?
I'm sorry, so we should wait for that email, or we should just sign up on the website?
You can go ahead and sign up. Go ahead if you want to sign up on the website. That's great. I'll send an email to everyone who came today as well. It's a Survey Monkey survey, so you can fill that out too if you're interested in starting. So great. Well, thank you everyone for coming. This was a good turnout on a beautiful day. So thank you for spending your morning indoors. And hopefully we'll be in touch soon. So thanks so much.
Many times before, but always good to get a refresher.
Yeah, we do. We have some that,
A number of projects, and it's too bad.
they haven't filed yet, and then we have others that are, that, they were up against the filing deadline and it's been filing, but, it's still. That, depending on how, you know, we've got pending cases that are.
So then I like get my thing, it was like the second day they signed it.
But it's not a rush. He specifically took 1 more day because he's out. And you could still get her.
Yeah,
No,
well,
She's
what
gonna
I-
be here for
Both of them that
she's
she
doing
for one.
I know, and so what we're
Yeah,
gonna
yeah.
have her do is she's gonna come to the meeting with the client, and, cause.
Yeah, I mean, maybe have, work with the attorney, and then if she wants to, let me know that you're, you know, that you're not.
Oh, is it?
So you'll be a contact person as well, you know, if you're the one that's meeting with the client.
Yeah, I worked with the
Oh, okay,
so I
okay.
do have the background.
Yeah.
That's when I got this, figured we had this thing real
Yeah.
long one. It's like, oh my gosh.
As you
I
say
couldn't
this,
have
you should
put
put it
it
together.
person ever,
Yeah.
so.
Yeah.
It was really.
Yeah.
All, like, all the way.
Oh, yeah.
Sarah.
I know, yeah, and even like countries where there's like some other part of that country where this is happening. So, yeah, it's fascinating.
And I love that part of it.
Yeah, great, okay, yeah, well, hopefully we'll.
Yeah, we'll get in touch with you and then we can start going on with things.
Yeah. Yes. Yeah, yeah, I know that is.
Right.
Thank you. Thanks so much for coming. You too.
Take it all in.
I don't know.
It's a lot of information, that's for sure.
Choose the screen, so.
Oh, okay, okay. I think she said something about that. She would do that. Breakdown too, so.
Yeah.
It'll be nice to.
I'll make sure too.
This is the last one. But I was doing it with another. So every time I sent something, it's that remote control. For that.
Great job. You not mind taking-
No, not at all. So should I get this to Anne?
Yeah, that would be great. Yep. Yes.
All right.
She'll know.
Okay, great.
And you have just a couple minutes, I can run something by.
Yeah.
A little bit. So, one of our clients, had a sign for, Monty.
Oh, yeah.
He has a massive.
That's what he said. Mother. I knew it was. Right.
So she's like, what's their name on his application? We got to review. They made us a, they said, their biological children. I think she's seen the doctor. And so we had to, we were taking a long. He said, because he went through, yeah, they're not biological. He didn't die. He didn't say. Biological
Yeah.
children, but we had to remove them from. And so we had to do it, otherwise. So now he got asylum, right? That's what, and he's talking about wanting to, bring them over. And we have 2 months now, because August was the 2-year. He didn't have the money to bring them. I just
Did
think.
he ever call me? I mean, that's the challenge.
I mean, I don't think we have a chance at all, but we're coming, we have 2 months, and we're gonna do something, and I wanna talk to him about it, but till now, I don't even know that it's.
So like.
Yeah, I mean, unless he's got anything to show that
Welcome.
No, he has no.
what the Ethiopia would recognize him as an author.
Just because I like material.
Yeah, I mean, is there, I mean, if he's been sending money, is that evidence
It
that
really
he's
changes how you
treating
think,
him as
it
children?
You know, we had a case,
Find it coming up, give it process. Like, I think
it was a,
I was walking around.
European
to my
case
apartment,
where
it is a manual.
the guy,
So a lot of them,
but his sister,
It was the first thing I thought about when I was
his sister was
development
developing
concern. I'm like, this is public land been for X. And it's like,
It
you
is
know,
true. You do start thinking of that.
it's really interesting because it's just like, it's a sidewalk. But I'm like, no, it's public land XYZ doctrine.
I just don't, it's one of those things where is it worth spending?
Exactly, that's a tort.
Because
It's
it would
gonna be
take
severe
a lot,
penalty.
first of all, getting over.
Yes, yes, someone would have known.
Yeah. I
If
mean,
they
I
didn't know,
would
then they
say,
should have known. So I was like, well, there was
yeah, I mean, it might make more sense for him to
So what we
citizen